Good day, Crime Talk aficionados. That's right, it's Saturday. What does that mean? It's time for the weekly recap of all of the top stories throughout the week, all in one convenient location. You are welcome. We'll see you next time. Thanks for watching. For the first time since Barry Morphew's arrest last year, the public is now able to see the photos of the evidence from the investigation into the alleged murder of his wife, Suzanne Morphew. Now, Suzanne, as you may recall, was reported missing on Mother's Day of 2020. A year later, on May 5th, 2021, Barry Morphew was arrested and charged with murder. He has maintained his innocence from the beginning. Chaffee County Judge Ramsey Lama ordered the release of certain exhibits, including video, photos, data, and audio, which were all presented to the court during the preliminary hearing. Now, we'll go over those in just a second, but recall, Barry Morphew is currently out on bond on a $500,000 bond, and under the rules of the court, he must reside in Chaffee County, but he can visit his daughters during the day in Gunnison, and he has the authority to visit his attorneys in Denver. The trial is scheduled for May 22nd, 2022, and as you may also recall, Suzanne Morphew's body has not been found, even though everybody believes that she is deceased. Now, let's talk about these exhibits really quick. First, there's really nothing new. There's some text messages. It sounds like Suzanne Morphew is complaining about her marriage. I think most people would agree it wasn't a great marriage. Then there's photographs of Barry Morphew at the hotel. It shows him with shovels. It shows him with things because he was working at a job site. That's what they purport to show. But the biggest thing, as they may recall, was the whole dart gun, the tranquilizer. Okay? This is the one that only on cross-examination did the government witness have to concede that the dart gun didn't work. And take a look at that dart gun, ladies and gentlemen. It's allegedly, well, it's held together by zip ties. All right, Judge Ramsey Lama. He's the new judge in the Barry Morphew trial. Well, guess what? He is moving Barry Morphew's trial into Fremont County on the grounds that Morphew could not receive a fair trial in Chaffee County, according to the court order. Now, as we all know, most people should know, Morphew is charged with the first-degree murder in the death of his wife, Suzanne Morphew, who disappeared from the family home or their close surroundings there in the county on May of 2020, specifically on Mother's Day. Now, the trial is set for May 3rd and will now take place in Canyon City instead of Salida. For your reference, Canyon City is about 60 miles east of Salida, and this is obviously a high-profile case, and it's a relatively small county with a small jury pool, which the court noted in its order. The media saturation is high. The pretrial publicity in this case has been massive and pervasive, and the prejudice that the defendant will not receive a fair trial is high. Let's just go straight to the order. All right. Now, the applicable law, the Sixth Amendment, ladies and gentlemen, the Sixth Amendment to the United States Constitution guarantees everyone accused of a crime, a criminal defendant, the right to a speedy and public trial by an impartial jury. That's right. And that has to be within the state and the district wherein the crime shall have been committed. And the court notes that the defense filed the appropriate motions, the prosecution filed their response, and there was a reply brief. The court went through the law, as they should in all good legal writing, and it says the factors to be considered by the court when determining whether there is such a massive, pervasive, and prejudicial pretrial publicity to bias a community include: 1, the size and type of the locale, the reputation of the victim, the revealed sources of the news story, the specificity of the account of certain facts, the volume and intensity of the coverage, the extent of comment by the news reports of the facts of the case, the manner of the presentation, and the proximity of the time of trial, and the publication of highly incriminating facts not admissible at trial. Remember that, because that's going to be significant. First, the court goes through its analysis, the size of the locale. He goes through the fact that Chaffee or Chaffee County, depending on what part of the state you live in, has 16,535 residents over the age of 18, living in 8,231 households. It's the type of community where people know each other. There are approximately 10,000 residents who live outside the cities and towns, with several thousand more part-timers who return to their homes during the spring and summer. The reputation of the victim. The court notes that Suzanne Morphew, once she was reported missing, the disappearance of Suzanne Morphew immediately garnered widespread community interest and media coverage. And according to Abby Jefferson, who's one of the people that filled out the affidavit that's required for a change of venue, many members of the community were highly suspicious of Mr. Morphew and his involvement in his wife's disappearance. And the defendant's exhibit demonstrate the media's portrayal of Suzanne Morphew and her reputation in the motions. And even more so, the court notes the defendant points to the annual memorial Christmas tree in Riverside Park in downtown Salida is there in honor of Suzanne Morphew. The revealed sources of the news stories. The majority of the sources covering the Morphew trial, as demonstrated in the record, exhibits provided by the court and local Chaffee County media outlets, is the local news channel. And they specifically reference the Fox 21 affiliate down there and Laura Schraff. And they also note that the local newspaper has received widespread publicity. The court also noted the specificity of the accounts of certain facts. Here they cite the news coverage related to the preliminary hearing and the proof evident presumption great. The volume and intensity of the coverage. This is what I think was the deciding factor for the court. Although the court goes through the analysis, I think this is significant. And the first thing he does is he blasts the district attorney. One, for making extrajudicial statements, knowing that there was a protective order, a gag order basically on the district attorney from making any statements. And when Barry Morphew is arrested, goes and comments on his silence, knowing that that would never be admissible in court whatsoever, but it was done only to prejudice the potential jury pool. And then she goes on profiling evil, and the court notes even the name is prejudicial. And so the district attorney to go on that podcast and materially prejudice the potential jury pool is basically unacceptable. Additionally, the extent of the comment by the news reports on this facts alone, the court says, listen, I'm taking basically judicial notice of the fact of the motions hearings that I've been involved in, and this is so pervasive that he's one of the factors why Mr. Morphew cannot receive a fair trial. He also notes that the trial is currently scheduled to begin in May, just over 3 months from now. And he says the publicity is ongoing and doesn't seem at this time to have to end to any of the publicity in sight. But this, I think, is the second biggest factor. One, the publication of highly incriminating facts not admissible at trial. So I've been taking a beating by several people saying, Scott, you don't know what you're talking about. You just want Barry Morphew to walk free. No. Listen, we give Barry Morphew the presumption of innocence. I don't know what, if anything, he did to his wife, okay? The court has said there's probable cause for a case to go forward. Now, whether the prosecution can prove that case beyond a reasonable doubt, we will wait and see at trial. But here's what the court notes, and this is what I've noted as well. The court has concerns about the information contained in the 130-page affidavit, something I had never seen in my 27 years. And the court notes that in his 30 years, he's never seen an affidavit like this. And a significant portion of the information in the affidavit was not relevant to the court's finding of probable cause and possibly not admissible at trial. Huge, ladies and gentlemen, huge. The court notes the presence of nearly 100 footnotes in the affidavit, which provides commentary from law enforcement on the veracity, the truthfulness of defendant's statements, along with statements about having declined a polygraph test and numerous photographs of him while being interviewed by law enforcement. The affidavit also contains statements from witnesses about Suzanne Morphew being a nice and a good person, and other statements expressing negative opinions about Mr. Morphew, both with regard to his alleged involvement in the disappearance of his wife and possibly murdering her. The affidavit also, as the court notes, includes numerous details from multiple sources of the Morphews' marital issues, their sexual history, and Suzanne Morphew's participation in an extramarital affair. This is not an exhaustive list of the type of information in the affidavit for which the court has concerns. Release of this information prior to input and redaction from the parties and prior to the defense beginning their investigation could hamper Mr. Morphew's ability to effectively prepare for this case. That is huge, ladies and gentlemen. I have said this, and you can criticize me. Like I said, I don't care if Mr. Morphew did or didn't do it. We're looking at this case, trying to look at it objectively. I have said the DA's case appears weak based upon my experience. Now we have the judge saying, District Attorney, you're screwing this case up. Now, he didn't say, what would Scott say? But basically, he said what Scott has said. The DA is screwing this case up. And oh, by the way, the police screwed this case up. And the court has commented now that the police should be held responsible. Basically, you have a change of venue problem, District Attorney, citizens of Chaffee County, guess what? Blame the police in their unprofessional preparation of that affidavit for an arrest warrant. More specifically, the district attorney going on talking about a high-profile case, knowing that there's a gag order in place. I just don't know what to say. And I hate to say, I told you so, but it's nice when people say, hey, Scott is correct. Not for my own ego, just for the people, the haters out there that say, oh, Scott, you just want Barry Morphew to walk free. I really don't care what happens to Barry Morphew. We're just trying to look at this and say, hey, is this man going to get a fair trial? Does the prosecution have enough evidence to prove this case beyond a reasonable doubt? So then you may say, okay, Scott, what is the significance of moving it to Fremont County? Well, the significance of that is that it is in the same judicial district. Under the rules regarding change of venue, the judge can move a case basically on motion or on their own motion to a jurisdiction within their same judicial district. The 11th judicial district includes Park County, Chaffee County, Fremont County, as well as Custer County. Now, hopefully Frank can put up a nice, better picture than what I'm holding up here. But as you can see, this is the area where it is. So the court had several options in which to go to. Now, why the significance of Canyon City? The defense may be careful what you wish for. The majority, I don't want to say the majority, a large population in Canyon City are people that work for the Department of Corrections and the Federal Bureau of Prisons, because that's where many prisons are here in the state of Colorado, as well as the federal prisons are down in Canyon City. So the residents usually work for the Bureau of Prisons. There's other people that work down there. There's beautiful things down in Canyon City. The Royal Gorge is down there. So not everybody works for the prisons, but that is a predominant group of people down there that work for the Department of Corrections. So we'll have to see if it plays out in the end. Bottom line is the prosecution is still screwing up this case. And instead of me just saying it, now you've got the court saying it as well. Maybe they need to figure out what they're doing wrong. Aiden Fucci, well, he is now 15, and as you may recall, he is charged with first-degree murder in regards to the 13-year-old schoolmate that he is alleged to have, well, stabbed to death. Is obviously charged with the brutal stabbing death of the schoolmate, 13-year-old Tristan Bailey. Well, he appeared in court today and learned that his murder trial will start in November, specifically November 7th, and go through the 18th. Fucci is charged with first-degree murder and will be tried as an adult, and he's expected to be back in court on May 5th for a status update. He's obviously pled not guilty. Now, as you may recall, Fucci was arrested days after deputies found Bailey's body near their home in Durbin Crossing, Florida, and investigators say his DNA was on Bailey's body. Now, Fucci's mother, Crystal Smith, also had a status hearing set for May 5th on separate charges, including tampering with evidence. Investigators said that she was washing blood off of her son's blue jeans while literally at the same time he was being questioned by police. And Bailey's body was found on Mother's Day, and The allegation is that the body was stabbed dozens of times, less than a half a mile from Fucci's home. And Fucci remains in the Duval County jail while he awaits trials. Alec Murdaugh. Yep, the privilege started young. So as people continue to dig into the background and life of Alex Murdaugh, it looked like he had a little incident when he was back in law school. And back on February 28th of 1993, Alex Murdaugh was accused of starting a violent brawl at a strip club on Hilton Head Island. Now, Murdaugh was 25 at the time, and he was enrolled at the University of South Carolina School of Law. 3 men were charged with public disorderly conduct, but only one of the men was taken to jail. Another was taken to the hospital. And well, Alec Murdaugh, he was driven home an hour and 20 minutes away by a deputy. Isn't that nice? Police just don't do that much anymore, do they? So Alec and the other 2 men charged that night were scheduled for a hearing on March 29th of 1993. And the report does not include copies of the tickets that were issued, just given the age of the case. But the background check done on Alex Murdaugh, and we've double-checked it, notes that the charge was dismissed on March 25th, 1993. And then Mr. Murdaugh graduated from law school just over a year later and was admitted to the South Carolina bar. And obviously, if you have a conviction, that kind of goes directly to your ability to practice law, and you have to disclose those things. Now, let's face it, 25-year-old guys, they're going to get in trouble. You hope if they're in law school, they're maybe exercising a little bit of good judgment. And what does this really show? Is this going to come into any court? No. Are we here just to disparage Alex Murdaugh? No, that is not our intent. In fact, basically, he never committed any crime. The case was dismissed, right? But what does it show? It shows the privilege started early down there in the Low Country. Hilton Head is part of the Low Country where his family has reigned for the last 100 years. And let's face it, when a deputy drives you home over an hour and 20 minutes away, that's some special privilege right there, ladies and gentlemen. The other thing that we're looking into, and I've mentioned this a couple of times, there's no way that he, being Alec Murdaugh, did this all on his own. There had to be so many people involved. We know there's been a couple of other attorneys where documents have been requested through the disciplinary bar out there in South Carolina, and those records have gone to bankers and other attorneys. The question was, I think that really the question is, was there somebody on the inside, maybe somebody at the court as well, that was making these things go forward? We're going to continue to follow this. I'm just, listen, ladies and gentlemen, it's just little old me, but I'm telling you, I have seen cases like this over the years, and that's why I keep saying it's very interesting, because it wasn't just one guy. And I think it's rather interesting that Alex Murdaugh has 2 of the most expensive attorneys in South Carolina, but yet he's broke. Somebody is paying those fees. Is that maybe they're just doing it out of the goodness of their heart, doing pro bono? Somehow, I doubt it. So it makes you wonder, who is paying those fees? And it is an effort to know what's going on or to keep somebody quiet. I think it's going to get more interesting than it already is, because it is interesting for sure. Michael Avenatti. He was just convicted of stealing nearly $300,000 from a book advance from his former client, Stormy Daniels. He now faces 22 years in prison, as the now twice convicted felon still faces additional charges in California, where he was also representing himself, but the case resulted in a mistrial because Mr. Avenatti was not provided all of the documentations that the prosecutor was relying upon. The jury concluded that for Avenatti to steal this money, he actually had to forge Daniels' name on a letter to her literary agent that directed him to wire payments directly from the entertainer to Michael Avenatti's bank account, where he allegedly spent the money on, well, luxury items like travel and a Ferrari. That's right. You never, ever represent yourself. It looks like Mr. Avenatti's once very successful and prominent career is just about over, and I don't think he's going to get house arrest on this one, ladies and gentlemen. Let me know what you think. Should he get the maximum penalty, or do you think he's a good guy who's just misunderstood?